Upon entering the military, service members take an oath to defend our nation. In exchange, the government promises to provide them with certain rights and benefits should they be injured or become ill as a result of their military service. With unshakable tenacity, proven legal prowess, and a steadfast commitment, the National Veterans Legal Services Program has built a remarkable legacy of advocacy to ensure our government does not break its solemn promise. It has done so by continuously adapting its programs, strategies, and tactics to match the evolution of veterans law. NVLSP has an outstanding track record of success through its 4 core programs and providing top-notch legal services to help secure wrongfully denied benefits. It has secured medical care, support services, access to TRICARE and other benefits that are invaluable to veterans and their families. It has trained tens of thousands of veterans advocates and has won upwards of 97% of its cases before the Court of Appeals for Veterans Claims. Since its founding 44 years ago, NVLSP has been keeping the promise and building a legacy of advocacy. A cornerstone of NVLSP's legacy lies in the class action lawsuits through which it has secured billions of dollars in benefits for tens of thousands of veterans and their families. The historic 1989 Niemer decision paved the way for the government to recognize a wide range of illnesses as a result of Agent Orange exposure. That victory enabled tens of thousands of Vietnam veterans and their families to receive critical care and more than $7.2 billion in benefits related to their exposure to Agent Orange. Richard Gilgenbach and Robert Marks are 2 of that class.
I joined the United States Marine Corps in 1964, and I went to Vietnam in 1966 to 1967.
We had to open up a brand new LZ. It was called LZ Baldy. And we had to build a perimeter and build the whole LZ from nothing. They would fly over it on the perimeter and spray Agent Orange. And the next day there'd be nothing left but sand and dirt.
We probably laid in it, we drank it, we probably slept in it, not knowing what this stuff was doing to us.
Both veterans suffered severe heart problems linked to that exposure. As a result of Niemer, both received the disability benefits they earned through their service. A related victory in the Niemer class action in 2020 enabled 60,000 Blue Water Navy veterans and their survivors to receive benefits related to their Agent Orange exposure offshore of Vietnam. In 2025, NVLSP achieved another major class action victory, this time in its first ever appearance before the U.S. Supreme Court. The lead plaintiff in the case is Marine veteran Simon Soto. Pro bono partner Sidley Austin was NVLSP's co-counsel throughout the case's 8-year journey through the federal court system. Tacey Flint made the oral argument before the Supreme Court.
Corporal Soto served a couple of tours in Iraq as a Marine, and he was on the mortuary services team in his unit. His job was truly heroic, recovering the remains of fallen soldiers, of his fallen comrades on the battlefield in Iraq in order to reunite them with the family of the fallen service member. Through that experience, he was afflicted with post-traumatic stress disorder. And after he was diagnosed with PTSD, he was determined to be, after a period of time, 100% disabled.
In 2016, he applied for combat-related special compensation benefits, which were granted. The Defense Department, however, limited its payment to Mr. Soto to only 6 years of retroactive pay. NVLSP and Sidley Austin challenged that determination in 2017 by filing a class action lawsuit on behalf of Mr. Soto and 9,000 other veterans.
Soto concerns combat-related special compensation, also known as CRSC, which is a Department of Defense side benefit for retired veterans that is in addition to VA disability benefits. NVLSP identified that the government was not providing veterans the benefits they were promised in the combat-related special compensation statute. We continued with our long legacy of defending the rights that Congress has bestowed upon veterans by taking up this case. And the victory in this case fulfills our promise to ensure that veterans obtain the benefits that they have been granted by Congress.
The U.S. District Court decided in favor of the Soto class in 2021. That order, however, was reversed on appeal, prompting NVLSP and Sidley Austin to petition the U.S. Supreme Court to vindicate the rights of thousands of combat-disabled war veterans. The High Court heard oral arguments in early 2025.
NVLSP and Sidley really brought both of their gifts to the table to make this as successful of a litigation as it was. NVLSP with its expertise, its experience in litigating on behalf of veterans, Sidley with our, experience in commercial class actions, enabling us to make this a powerful class action. Then once it got to the Supreme Court, our expertise in Supreme Court litigation, working together was produce the kind of synergy that is really a joy to see. Through working with Rochelle, Renee, and the entire NVLSP team, as well as Emily Wexler here at Sidley, I do not know how a person who is not a lawyer and also not an expert in military benefits could possibly accomplish this on their own. I'm sure some people have, but having NVLSP to support veterans in this really difficult and complex process of applying for benefits, fighting for benefits if they're not paid as they should be. I just can't say enough about how important that is.
The Supreme Court was unanimous in its ruling, finding that combat-disabled veterans are indeed entitled to payment of combat-related special compensation, without regard to when they applied for the benefit.
While we are thrilled with the victory in Soto, this is not the end of NVLSP's work for veterans entitled to combat-related special compensation. We are continuing to monitor the implementation of the Soto decision to ensure that veterans receive the full retroactive benefits they have earned.
NVLSP is constantly working to extend its reach and maximize its resources to assist as many veterans as possible. Central to that philosophy is the Training and Publications Program. A cornerstone of that program is the Veterans Benefits Manual. It is considered the indispensable guide for advocates who help veterans and their families obtain benefits from the Department of Veterans Affairs.
I think the Veterans Benefits Manual is so essential because it strikes the right balance between in-depth analysis of the law and advocacy advice, but it's at a level that's accessible to any practitioner. Anyone from a veteran service officer who's a non-attorney helping a veteran at the VA regional office to an attorney who might be handling a case even at the Supreme Court. It covers all aspects of the veterans benefits system.
The VBM was first published in 1991 as a 900-page volume. The 2025 edition spans more than 2,000 pages and includes new sections that address new aspects of veterans law that have developed over the more than 30 years it has been published. Each year, NVLSP conducts virtual and in-person training sessions, educating lawyers and non-lawyers alike about the intricacies of veterans law, equipping them to provide sound representation.
Our goal in the training program is to try to reach as many veterans advocates as possible and train them to ensure that the veterans they represent receive all of the benefits they've earned through their military service as quickly and as early in the process as possible. Benefits delayed can be benefits denied.
NVLSP's vast selection of webinars, in-person trainings, and online basic training course cover a range of top issues and reach thousands of advocates each year.
We've trained over 50,000 veterans advocates, attorneys, veteran service officers, agents who represent veterans. And in NVLSP's history, I would say well over 100,000, probably much more than that, probably closer to 200,000, 250,000 advocates across the country. I think our training program and our Veterans Benefits Manual contribute to NVLSP's legacy in the sense that it allows us to be a force multiplier. We have a relatively small group of attorneys. I mean, we've grown over the years from a handful of attorneys to now nearly 50 attorneys on staff, but we can only represent so many veterans. Our training program allows us to reach magnitudes greater of veterans than we would be able to do otherwise. We are able to help service officers across the country and attorneys across the country get the veterans that they represent the benefits that those veterans have earned.
NVLSP collaborates with state departments of Veterans Affairs throughout the United States. Today, that network of partnerships encompasses 36 states. These partnerships are instrumental in amplifying efforts to assist more veterans. Through the Lawyers Serving Warriors program, NVLSP partners with volunteer lawyers from over 100 national law firms and corporate legal departments to train and mentor volunteer lawyers so they are prepared and qualified to handle referred pro bono cases before the DoD and in court. LSW partners with pro bono lawyers on class action litigation involving systemic issues impacting 4 DoD programs: discharge upgrades, medical retirement, the Service Members Group Life Insurance Traumatic Injury Protection Program, and combat-related special compensation, as in the Soto case. NVLSP also assists veterans, service members, and their families in individual cases to secure the DoD benefits they have been wrongfully denied. One such case was Peter Guidry.
I joined the Air Force because of my grandfathers. They both served, and some of my uncles served in the military as well, so I just wanted to follow in their footsteps. My first duty station was Aviano, Italy, and I did security forces, so I worked in restricted areas guarding the equipment and personnel.
We met in Italy. It was my first duty station as well, and I got there November '97, and we got married 6 months later. And it was literally love at first sight, which sounds so cliche and crazy, but it was.
My primary duty was protection of the airplane, so we carried an M60 machine gun. And so that was the genesis of the start of my disabilities. When you're carrying a gun that's weighing 23 pounds in one hand, your body becomes off-center. The injuries caused me to have spasms, so my upper and lower back completely locks up. I literally turned into Frankenstein, who wasn't able to move my head left or right. It left me incapacitated for days on end.
Mr. Guidry eventually was deemed physically unfit for duty and discharged by the Air Force, but he was denied a disability retirement and the medical benefits that go with it.
He got medically discharged. He actually felt ashamed. He felt like he had let his grandfathers down. The hardest part was watching him suffer and not being able to help him. I could see the physical, and I experienced the physical, but the mental was far worse. You're like 24, you have a wife, you have a home, a mortgage, and I didn't realize how scary it must have been for him to just be out They didn't give him any retraining, they didn't give him anything.
Mr. Guidry turned to NVLSP for help in navigating the military's Byzantine benefit system, with the hope of reversing that decision. NVLSP enlisted pro bono partner Latham & Watkins in the effort. The team submitted its brief to the Physical Disability Board of Review, but was denied. Because there is no option for appealing a PDBR decision, it took the unprecedented step of appealing the ruling in federal district court. That court ordered the PDBR to reconsider Peter's case. When it did, Mr. Guidry was granted the medical retirement he had earned. That decision allowed him to receive a stipend from the military for the rest of his life. It also allows him and his family to access the military healthcare system, TRICARE. Today, more than 5 years after securing those benefits, Peter and Kelly are paying it forward to the veterans community through the nonprofit they founded, Forgotten Not Gone. Their organization advocates on behalf of veterans, works to prevent veteran suicide, and provides other programs and services to support their fellow veterans in their return to civilian life. NVLSP's appeals to the Court of Appeals for Veterans Claims program has secured over $50 million in retroactive benefits for veterans since 2020, filed over 1,000 appeals in 2025, and consistently achieved a success rate of over 97%. Whenever a veteran's claim for disability benefits is denied by the Board of Veterans' Appeals, they have the right to appeal the board's decision to the U.S. Court of Appeals for Veterans Claims, or CAVC. Generally, a board decision must be appealed to the court within 120 days, but that process is daunting for those unfamiliar with veterans' benefits law. NVLSP appellate attorneys are experts in reviewing these decisions for error. We have represented scores of veterans before the court, securing the much-needed medical benefits they have earned, all at no cost to those former service members. Retired Air Force Major Wes Carter is one of those veterans. He was among 2,100 reservists and National Guard service members who flew training and assigned missions from 1974 to 1980 in aircraft that a decade earlier had sprayed the toxic herbicide Agent Orange during the Vietnam War. In 2011, Mr. Carter was diagnosed with potentially lethal prostate cancer, and he suspected there was a link between his cancer and the C-123s he had flown. Mr. Carter had heard from a number of reservists who had flown those planes with him that they too had one of the types of cancer, like prostate cancer, that the Department of Veterans Affairs recognized as associated with Agent Orange. Mr. Carter filed a disability claim with the VA. Even though his VA doctor declared that the cancer was likely related to exposure to Agent Orange, the VA denied Mr. Carter's claim and those of the other 6 C-123 veterans. Undaunted, Mr. Carter continued his fight, and ultimately his efforts eventually moved the VA to admit the service connection between his illness and those of the other sick veterans to the tainted planes they had flown. But the VA refused to honor the full time period of his claim, denying Mr. Carter and others 4 years' worth of disability benefits.
We had pilots, we had flight nurses, we had maintenance folks. They were all denied, every single one of them. So I contacted NVLSP.
NVLSP and pro bono attorneys at Faegre teamed up to seek full benefits for Mr. Carter retroactive to 2011 when he filed his initial claim. They filed an appeal with the Board of Veterans' Appeals and wrote a brief providing evidence that Mr. Carter met the criteria for exposure to a toxin as an injury. The BVA agreed to expedite the appeal. In October 2017, the board agreed to pay the veteran benefits back to 2011.
My claim was submitted to the VA in 2011. The impact was immense to me, but what's more important to me is that it serves as a model for what other veterans can turn into the VA and effectively have their claims made retroactive. Wouldn't have happened without the NVLSP.
Mr. Carter continues advocating for fellow veterans in his home state of Colorado to secure expanded benefits. He was instrumental in securing a disabled veteran property tax exemption for Gold Star spouses living in the state. Carter also assists fellow veterans file claims for benefits connected to aviation-related cancers. While much has changed since our founding in 1981, NVLSP's commitment to seek justice for our veterans, service members, and their families at no cost to them is unwavering. Through our class actions, training and publications, lawyers serving warriors, appeals to the Court of Appeals for Veterans Claims, and other programs, NVLSP is keeping the promise and building a legacy of advocacy.